Court does call the case of the People versus Stephen Johnston.
A.K. Richard McDuffie for the people. And Allison on behalf of the people, Your Honor.
Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Johnston.
All right. I put this over to this afternoon. What have we determined?
Yes.
Right from the jump, the courtroom energy is tense. Watch how fast this hearing turns from routine to full-on damage control.
Good evening, well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to the circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up.
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give the change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name.
Can we approach, Your Honor?
Yes. I need counsel. Go ahead. Go ahead.
Yes. So in addressing the prosecution's request for a no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Conkey there made a determination that contact would be.
Quick breakdown. Waiving up means the defendant skips the lower level hearing and sends the case straight to circuit court. It's a bold move, sometimes strategic, sometimes chaotic. Stay with me.
Proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, between the time of Judge Conkey's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
While context may be changed, he has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a violation of his previous probation. So
right, okay, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr.
Notice what's happening here. Both sides are dancing around the real issue, contact with the alleged victim. This is where judges get hyper-cautious, because even any questionable phone call can reshape bond conditions.
Buckovich?
yes, I would understand what you're saying here.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waving up.
Yeah, we get you in front of Kunke.
You know what, Your Honor? I might as well just wave up the conky.
Okay.
Okay, if that's what you wish to do. Sir, you.
Tells me addressing bond. I'm not changing when it was no contact with her. That's what I was addressing. I'm not gonna be right towards you.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening. So I would still be asking for a.
You're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Odosella, Mr. Buckovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised the red flag.
Here comes the twist. Johnson speaks up himself. And anytime a defendant jumps in emotionally, judges get nervous. Listen closely. He claims innocence, planted evidence, and wants contact with his fiancée. This is where cases often derail.
For me, with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now. So the people are, again, requesting a simple but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
All right, here's what the court's gonna do. Well, is he waving up or what's he gonna do?
He's waving Kunke.
Or did you wish for the adjournment, Mr. Frank?
Your Honor, I'm quite confused on a couple of things. If I'm able to speak to you for a second, the complaining witness of who they are talking about. I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke, Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Kunke's courtroom, Your Honor. And by me not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with a
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
What she did?
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm.
And here it is, the judge hits the frustration threshold. You can literally feel the moment the courtroom temperature spikes. What do you think? Is the judge being too strict here or just doing damage control?
I'm not able to have contact with her. She didn't put me in this predicament. Her doctor.
Sir, I
Did a
advise you
welfare
stop making
check on her.
statements. I advise you stop making statements, because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No.
do the
Give me
waiver?
the pen.
He's-
I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to. I
I'm not
get it.
taking his waiver. I'm just going to adjourn this out. You can talk to your client. He can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me.
I'm
I
not,
don't even know why. I'm making the findings based upon what's presented to me. But if he's going to act this way, I'm just not having it. So
Would you like to briefly pass this matter so I can speak to my
no,
client? Your
I'm
Honor?
not going to pass it. I'm going to adjourn
not
this
mad.
to another
Oh.
day.
I'm not mad.
I'm going
not
to
upset.
adjourn this to, give him 1 week out. We'll go June 5th, 2025, 9 a.m. or
Mr.
as
Sim-
the invite indicates. I am at this time going to change the bond conditions. I'm going to leave his bond in its monetary amount as it's set. I am going to order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also going to indicate that there's no contact with Christian Kanuski. I'm going to order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm going to put up with his behavior, I'm not doing it. I'm
Your
done.
Honor,
Thank you.
I'm not upset, Your Honor. I said just.
Okay.
Not even upset at all.